Hi everyone, I'm Dipa Swaminathan, the founder of ItsRainingRaincoats, and with me here is lawyer and personal injury claims expert Raj, and we're here today to talk about workplace injuries. Hi Raj.
Hi, Deepa, and hi, everyone.
If a worker is injured in the course of employment, how does he recover compensation?
There are two ways to recover compensation. The first way is through a WICA claim, that's the Work Injury Compensation Act. And the second way is to recover through a common law claim, which generally goes through the court process. So in WICA, it is no fault based. Essentially, the accident happens in the course of your employment, and your compensation is assessed based on three heads subject to a cap. So the first thing that you have is permanent incapacity. The second aspect of a WICA claim is your medical leave wages. And the third aspect is your medical expenses. For a common law claim, on the other hand, it is fault based. You need to prove negligence or breach of duty on the part of your employer or a third party, and the damages are generally much higher. They comprise general damages for pain and suffering, general damages for loss of future earnings or loss of earning capacity, cost of future treatment, and there's no cap on these items. And then you have special damages where you are compensated for your expenses up to the date you receive your award. And this would also include medical expenses, loss of income, transport to see your doctor, and also compensation for loss of your personal belongings, for instance, your handphone and stuff like that.
So, how does a worker decide if he should pursue a weaker claim or a common law claim?
So, as I said, compensation for weaker claims is non fault based. So, the compensation is much lower. Essentially, if you yourself are at fault, or no one in particular is at fault, then generally you would go for a weaker claim. The compensation process is also much faster. Generally, it's estimated that you get your compensation within 6 months. However, if someone else is at fault for the accident, for example, it's a breach of your employer's duty to provide you with a safe working environment, a safe system of work, or adequate manpower to help you do the job, then you can establish fault on the part of the employer, or if you're involved in a traffic accident and the third party is at fault, you would then commence a common law claim against that third party or your employer. And as I said, the damages are generally much higher, but it takes longer as well. Two things can help a workman while he's waiting for this award in common law. First, you can rest assured that the courts award interest on your damages if the claim drags on. And secondly, you can also have your lawyer apply for an interim payment to advance you monies to tide you over while you're waiting to receive your award.
Okay. And who is typically eligible for WICA?
All right, so to be eligible for WICA, you generally must fall within the definition of a workman under the Act or someone who's serving an apprenticeship. The Act does not cover independent contractors who are in business for themselves, domestic workers.
Okay. And what is typically considered a workplace injury? For example, I mean, obviously, if it happens in the course of work, that's obvious. But what about if you were traveling to work, you were on the lorry on a highway to your work site, or if there was a fight at work between two workers? So what is the ambit of a workplace injury?
Right. So the critical aspect is that the injury must occur in the course of your employment, either at your workplace or while you are going about doing your job. This course of employment can extend to overseas assignments or when you are deployed to the work site of another party, for instance, a main contractor for another project. It also covers transport provided by the employer traveling to and fro from work. But of course, if you are taking a detour for your own personal agenda, then it is not covered.
Okay, that's very clear. Thank you. And what is the first thing a worker should do if he sustains a workplace injury?
Right, if you sustain a workplace injury, the first thing you should do is alert your employer and your colleagues to the fact that you have been injured, and then, of course, seek medical treatment. And when you do, it would also be advisable to explain to the doctor how the injury occurred. The doctors would also need some account of how the injury occurred so that they can better diagnose your clinical history and the injuries. And that way you establish that the injuries that you suffered are consistent with a workplace accident.
And what if the employer doesn't believe that this was a workplace accident? He, for example, contends that this was some kind of a pre-existing condition or, caused, sustained before the worker arrived at the workplace. What kind of evidence do you suggest the worker collects to support his claim that this is a workplace injury?
Right. So you would, of course, have situations where the employer is disputing that this accident was a workplace injury. In those situations, what would help the worker is if the worker has promptly lodged a report with the employer as well as an I report with the MOM. The worker would also probably show using medical records that he had no prior complaint of an injury until this occurred. And the best thing to do in these kind of situations, frankly, is consult a lawyer for help.
Okay, thank you. That's great advice. Now, if the employer refuses to pay the medical bills, does the worker need to pay it himself first?
That's a good question. Now, under WICA, the employer is obliged to pay for the medical expenses up to a certain cap. And if the worker pays in advance, the employer is also supposed to reimburse the worker. You also have the Employment of Foreign Manpower Act, where the employer has to pay the hospital directly, and in practice, hospitals also require the employer to endorse a form where they undertake to make payment of these medical expenses. So I think the law does provide adequate protection for the worker here.
So, what is the extent of claims that a worker can make for a workplace injury? For example, if he's gone to a GP and the GP's referred him to a specialist, and then he requires to be admitted for a surgery and he's on medical leave for, say, 3 months. And when he's finally discharged, the doctors tell him that he'll walk forever with a limp. Taking that as an example, what could be the extent of his claim?
Sure. That's a good question. I think let's break it down into WICA on the one hand and common law on the other hand. So, taking the WICA context, if the employee can't prove that the employer is at fault or a third party is at fault, he would go under WICA compensation. WICA compensation would compensate him for, firstly, the percentage permanent incapacity. So the doctors would fill up a medical report detailing what is the percentage permanent incapacity arising from that limp. Following on that, if you look at the schedule to WICA, it will tell you how much compensation you get for that percentage permanent incapacity. You can also check how much you are going to get on the MOM website because they have a percentage incapacity calculator. So that would be the first component under WICA. The next two components would be your medical expenses up to a cap of 45,000, and your medical leave wages, which are awarded to you based on your full income for 2 months, and thereafter for the next 10 months, 2/3 of your salary. So when you add that up, that's the WICA compensation. Now, if on the other hand, the worker here can prove that the employer or a third party is at fault, then the worker should really be going for a common law claim. So under the common law claim, the worker will get general damages for pain and suffering for his leg injury. He would also get general damages for loss of future earnings if his income drops permanently as a consequence of this disability. And the third thing he would get as general damages for a common law claim is the cost of future treatment that he requires for this injury. The doctors will produce that in the form of a medical report. So those are your general damages under common law. You have special damages as well under common law, and these special damages will compensate the worker for his medical expenses without a cap, his medical leave wages, again, no cap, as well as his transport expenses and any damage to his personal property, for instance, his mobile phone. Now, when you add all that up, those would be the common law damages. So, for instance, if the worker has been held to have contributed to the way the accident happened through his own negligence, and he's held perhaps 10% liable, he would then recover 90% of those damages. So that's where you have the distinction between a WICA claim and a common law claim.
Okay, thank you. Now, what can a worker do if after submitting a WICA claim his employer doesn't pay him?
Now, after he submitted the WICA claim, if the employer does not pay him, there are various help agencies that the worker can turn to. If you Google the MOM website, it will become very clear to you.
Okay, great. And how long does it typically take to get paid in a WICA process?
Right. So WICA is no fault. The compensation is much lower for that reason. And it's also designed to be much faster than a common law claim. So the average time that we understand a WICA claim to take is about 6 months. For a common law claim, on the other hand, it can take much longer because you have to prove your case. And a common law claim can range anywhere between a few months to a few years, depending on the nature of the injury and how far the court process goes. But there is always recourse for a worker if he's waiting for a common law claim. He can get an interim payment up front, that is an advance payment once he can establish that the other party is going to be substantially liable and they are insured. The other aspect of a common law claim is because it tends to go on for longer, the worker also gets interest on his damages. Does that answer the question?
It does. It does. Thank you. Now, supposing a worker is watching this video and realizes that an injury he sustained, say, 2 years ago, is actually eligible for a claim, but he never made it at the time, can he do so now? In other words, how long after an injury was sustained can a worker start the claim process?
Sure. The starting point for under WICA is that there's a 1-year time bar. So beyond that, the worker cannot make a claim under WICA unless the commissioner decides that there are exceptional reasons. The other alternative in this situation would be to make a common law claim, because for common law, there's a 3-year time bar for personal injury claims.
Okay, so 1 year for WICA and 3 years for
That's
common
right.
law.
1 year for WICA, 3 years for common law.
Okay, great. Now, can an employer fire his worker because he's unable to work on account of a workplace injury?
Legally, an employer is entitled to terminate the worker based on the terms of the contract, but it doesn't mean that if the worker is terminated, he cannot get compensation under common law or WICA. In fact, this may cause the claim for loss of income to be much higher as a consequence.
Okay, that's good to know. Now, can a worker claim both WICA and common law? Can he sort of double dip?
No, you can't bring a claim for both WICA and common law. You need to elect whether you want to receive compensation under WICA or whether you prefer to proceed under common law. And here is where I think workmen need to be careful. WICA compensation tends to be much lower and it tends to be faster. So there's a limited time within which you have to object or withdraw your WICA claim in order to bring a common law claim. Once that time has lapsed or you have accepted the compensation under WICA, you can no longer bring a common law claim.
Okay. So, what can a worker expect to pay as legal costs, and how would he know if he's being overcharged?
All right, so let's take this in terms of common law claims first and then WICA claims. So, in a common law claim, when the worker receives his damages, the paying party would also be ordered to contribute to his legal costs. And we call that party and party costs. And generally, as a rule of thumb, the lawyer would be charging the worker that party and party cost contribution, as well as perhaps 1/3 of that as a solicitor and client component. So, for example, if the claim is about $30,000 or $40,000 and the party and party costs are about $4,500, what the lawyer would be charging the worker is that $4,500 plus $1,500 from the worker's damages, and the worker should be getting the rest of those damages. That's for a common law claim. Now, for a WICA claim, generally a worker is not going to need a lawyer because it is now an automatic process whereby once the reports are lodged, the insurer assesses the claim and makes payment. But if the worker seeks to dispute the amount payable, or the employer is disputing either the amount payable or whether it was incurred in the course of employment, then the worker could get a lawyer. Now, in this situation, it's a bit less clear-cut because the party and party costs awarded in the MOM forum tend to be quite low, and there doesn't seem to be any control at present as to how much the lawyer charges the client. So if you're planning to dispute an MOM claim, in other words, a WICA compensation award, you should check with the lawyer beforehand what the likely compensation is going to be so you know the amount that you're fighting over and how much the lawyer estimates that he will charge the client.
Okay, great. So, you can hire lawyers for WICA claims?
You can hire a lawyer if you want to contest, for instance, the permanent incapacity or the total award in terms of your medical expenses and your medical leave wages. Or if the employer, for instance, is disputing that it was a workplace injury.
But is it possible to do a WICA claim without engaging lawyers?
Yes. In fact, nowadays, once the worker has reported the accident to the employer is then supposed to put up the relevant forms, and the insurance company of the employer will assess the compensation and make the compensation within a specified time. So, in those situations, you do not need a lawyer.
Right. Okay, great. And we come to our last question now. What if the employer, if there are medical expenses the worker is incurring during the claim, is the employer required to pay those medical expenses?
All right, so for a WICA claim, the employer is expected to pay the medical expenses up to a cap, of course, of $45,000. in a common law claim, the employer would have undertaken to make payment to the hospital, and thereafter, if the employer is not paying any further medical expenses, the lawyer can take it up and ask for an interim payment.
So we've come to the end of the session today. Thank you so much, Raj, for your time and your excellent answers. I've certainly learned a lot today, and I'm sure our workers have too, and I've no doubt they'll find this extremely useful. So thank you so much again.
It's been my pleasure, and you're most welcome.